Welcome back to Viewpoint. What happens when the right to freedom of speech clashes with the right to respect for one's private life and reputation? This question was examined by lawyer Julian Santos at a University of Gibraltar lecture this week. Julian spoke to my colleague Shelina Asamal about privacy and defamation, touching upon his involvement in a very high-profile case.
The idea behind the lecture is to give an introduction to what I loosely refer to as the publication torts. Given that it's an area of tort law which I think all modern lawyers need to be familiar with, especially in Gibraltar, where we're all generalists, so we need to be familiar with these kinds of things when the problems arise. And by publication torts, I mean the following: privacy, breach of confidence, defamation, malicious falsehood, data protection, and harassment.
Where is the line between a misuse of information and invasion of privacy?
There are two different ways that the court has used to describe essentially the same conduct, which is intrusion into someone's personal life. It started as misuse of private information because that was the case of Naomi Campbell suing the Mirror, and that was the way it was termed then. But as the tort has evolved, the court has started to realise that it's not just about misuse of private information, it's more about invasion into someone's private life. So in the more modern cases, they've started to describe it as invasion of privacy instead.
And the second right that you've spoken about is the respect to one's private life and reputation. So can you explain what that is?
Yes, the courts and our constitution recognise the need to protect one's private life, to protect one's reputation. One's private life is not purely what one does behind closed doors and in secret. It's what everyone does when engaging with their friends, their family, and the parts of our lives that we aren't particularly comfortable with every single person in the world knowing about. And that's probably the best way to put it. Just because something isn't secret doesn't mean it isn't private, and just because something isn't private doesn't mean it can be that it isn't confidential. So they're two different things. I think that's the way that I would explain it.
And so how do these fundamental rights clash with one another? And could you provide us with some examples, perhaps, of when they have?
Yes, the classic example is where there's a person, a well-known individual who is very well known to the public, and at the same time there's information about that person that is highly private. People may be very interested in hearing and learning about that private information, and then newspapers or broadcasters may be very keen in publishing it. To the extent, what the courts say is that if it's contributing to a debate of general interest, then the newspapers and the broadcasters should be allowed to exercise their free speech and publish it. If it's not contributing to a debate of general interest, if it's just curiosity, gossip, tittle-tattle, that kind of thing, then the courts aren't going to protect free speech and are going to prefer the privacy rights.
In the UK, you can only bring a defamation claim within 1 year of publication. In Gibraltar, you can bring a claim within 6 years of publication. That's a stark difference, and this was actually raised in a recent case that I appeared in, the case of Cruz and Barras and others. Now, I'm not going to comment on that at all, because it's still ongoing litigation, but I just refer to the judgment of Mr. Justice Yates of the 31st of January of this year, because the defendants were arguing that the limitation period had simply not been reviewed in Gibraltar, and that if it would have been reviewed, it would have been brought down to 1 year. And the only reason why it hadn't was because defamation actions aren't as common, and the policymakers must not have applied their minds to the considerations which have informed the changes in England. That was the argument that was run. Mr. Justice Yates noted this, and without disagreeing with it, or agreeing with it, simply said a litigant is entitled to rely on the law as it applies to him. So that's the scenario that we're in. Now, I wouldn't advise someone leaving as I actually once did many years ago, leaving a claim till the 11th month of the 6th year to bring, because a court might start questioning whether you're genuinely interested in vindicating your reputation.
I think the limitation point is a separate issue, and there are pros and cons. When it comes to criminal libel, and I need to make clear, don't mention it by way of criticism to anyone because it hasn't been used. I can't remember it being used in my lifetime, I have to say. But it's something that's still on the statute book, and there's been an effort in the whole of Europe really to move away from that. It's seen as something that is an inhibition on free speech. It's seen as something that is unnecessarily threatening because the courts are there already and can deal with things in a civil way in terms of giving people damages where they've been defamed. And it's a completely personal thing, I don't think that people should be fearing prison when they say something. So it's just a case of modernizing. I don't for one second believe that any government would seriously consider it, but if that's the case, then I don't see what the point of the provision is.
So you would recommend modernizing this legislation and amending it accordingly?
Yes, I think that's right. I think I pointed out one or two specific provisions which are in need of a little bit of modernization.
Could you remind us of those? Yes,
one of them was the criminal libel, and the other was a provision which comes from the Slander of Women Act in 1891 in the UK. That seems to me to be particularly antiquated. It distinguishes between genders in a way that I don't think is particularly modern thinking, and I don't think is particularly necessary. And I think that the best thing to do would be simply to get rid of it. Again, it's one of those that hasn't been used. I haven't seen an example of it ever being used in Gibraltar, but given that that's the case, I don't think that it would be too problematic to simply just remove it.
For our viewers who might not be as familiar with legislation, could you explain a bit more casually what it might say?
You're testing my memory, but what the rule says is that where an allegation of inchastity or extramarital conduct is made against a woman or a girl, they're not required to show any loss in order to bring a claim. Whereas if it was made against a man, they would be required to prove loss. Now that, looking at it completely neutrally, gives an advantage to, can be said to give an advantage to women. I'm sure that women probably wouldn't see it in that way, and it's, in my view, based on antiquated thinking. There's no difference, in my view, between an allegation of adultery against a man or a woman, and our laws, in my view, shouldn't be distinguishing between them.
We run into problems in social media because it's very difficult to actually pin people down. And Monia and Wood was a case that I appeared in where that was right at the heart of it. And we had 7 days in the High Court arguing over whether someone was responsible for one tweet. And this was an extremely defamatory and false tweet about the claimant, which was published by the official account of the Bristol branch of UKIP. I didn't think that Bristol had a UKIP branch, but there you go. I think most places do. But this was an unincorporated association, so there was no legal relationship between them, and it was done during the May 2015 election campaign. So the claimant, who was horrendously libelled by this tweet, decided to sue the chairman of that unincorporated association. The chairman said, I didn't publish the tweet, I wasn't aware of it, so you can't sue me. The tweet was published by the branch's unpaid campaign manager, who also had a second job as an amateur porn actor, who went by the name of Johnny Rockard. I'm not making this up, I promise. the court held that although the chairman was not was not directly responsible for the tweet, he was held liable for it in two ways. First of all, it was published on his behalf by his agent, and when I say an agent, that need not be someone who has the job title of agent, need not be someone who's a paid agent. An agent is someone who is authorized to act on your behalf. So this individual who'd been given control of a social media account that had many followers and was publishing as part of the chairman's campaign was held to be acting as his agent. It sufficed that he published the tweet for the purposes of the campaign, and that the role had been delegated to him specifically by the chairman. And secondly, the other way that the claimant was held to be responsible for the tweet was that when the claimant read the tweet and called up the UKIP office, the chairman actually picked up the phone, and the claimant told him about the tweet, and the chairman told him, and I quote, to piss off. Those words, piss off, were taken to be a ratification of the tweet. So on the basis of that, he was taken to be responsible for it.
For those who are especially outspoken on social media, what would your advice be to them to ensure that they stay on the right side of free speech?
Well, my advice to them is to keep doing what they're doing. That's what's important in a modern society, that people express themselves. But just be careful not to make, unless they are completely sure that they're true, not to make allegations that harm other people's reputation. And it's normally possible to do that. It's not always possible to do that, but in most cases, I think if you take a step back and say, what message am I trying to convey? Can I do it in a way that doesn't infringe on someone's private life or doesn't harm someone's reputation? You probably can. If you have no choice, then probably you should see a lawyer before you do it.
Of course, we've seen the effects that referendums can have on people's claims in the news, in social media, and Gibraltar too has a referendum coming up. So naturally it will be a time when people take to social media and make comments about things more often than they might normally. So what would your advice be for that as we come closer towards it?
I think that one has to be very careful not to descend into making accusations against individuals, especially false or harmful accusations. Gibraltar has always been a very highly politicized place. We've always engaged in political battles with each other. Everyone has an opinion on every topic, and rightly so. That's what causes us to be such a wonderful place. But those debates can be had without making allegations. And if people start making personal accusations and harmful accusations, well then that's what the law is there to prevent from happening. So I would urge people to try and keep the arguments clean and try and avoid such situations.
In the phone hacking litigation, where I act for the claimant group of the victims of phone hacking, the mere fact that the information was obtained illegally and covertly weighs into the test of privacy. So that in itself is a very strong factor when considering whether information is private.
Of course, you are representing a claimant group that includes Prince Harry, among others, in two phone hacking claims against publishers from a number of British tabloids, including The Sun, The Sunday Mirror, The Daily Mirror, The People and the News of the World. So what can you tell us about this case?
I'm very limited as to what I can say because I'm acting in the case. It's a claim that's brought by individuals who claim that their voicemails were intercepted and that other unlawful information gathering techniques were used against them to obtain private information that then found its way into tabloids. And this litigation is a way of them bringing their claims and seeking compensation for those activities, if they did occur, and for the newspaper to defend them, the newspapers to defend them as they deem necessary. I act for the group of claimants who are the individuals who believe that their voicemails were hacked in the periods between the 90s and 2010, 2011.
So where is this case at now? How far has it progressed?
There's a very large number of claimants. There have been hundreds of individuals who believe that they were hacked. Many of them have brought their claims. Many of the claims have settled. There has been one trial where awards of damages were awarded, and we're currently dealing with the next crop of people who are bringing their claims, and there are trials listed for October of this year and January of next year, where if the cases don't settle, the court will decide whether they have valid claims, and if so, how much money is due to them in terms of compensation.
I appeared for the Chief Minister in the case of Picardo and Manos Limpias, which was a claim by the Chief Minister against the Spanish Union that had accused him of some very serious crimes in what was a clearly quite fantastical publication, but nevertheless was making very serious allegations. And during the damages hearing, the Chief Justice, Mr. Justice Dudley, made a very interesting point. He said, well, the Chief Minister is going to be concerned about what people in Gibraltar think about him. People in Spain are poisoned day in, day out by the press with false allegations. So this is probably nothing new for him in Spain. In Gibraltar, everyone treats anything that's said by the press in Spain with complete distrust and knows that a lot of the Spanish press is prone to making up allegations when it comes to Gibraltar. And he said, I'll go further. A chief minister, if he's not getting this attacked in Spain, isn't doing his job well enough.
So in your talk you mentioned cavalier attitude celebrities can have. So if they have been inviting of the media in the past into their private life, what does the law say about their rights afterwards?
It can have an impact on their rights. It's not a simple equation of just saying, well, you've attended these public events and therefore you forfeit all your rights. But if you're someone who has regularly sought to attract the media into your private life, if you're someone who has given double-page spreads and has never shown any regard for your private life in the past, then it becomes a lot harder to try and protect it. That, as I say, the courts don't say that just because you've done that you have no private rights, but you might find it a little bit more of an uphill struggle if you've shown no regard whatsoever for your private life in the past.
So we're talking about celebrities here, but because they're high-profile individuals, but this applies to all people equally?
Yes, it's just that it seems to come to a head with celebrities because they are in the public eye, and actually that's what drives some of the newspapers that most commonly publish private information. But yes, I've had cases where we're suing in privacy and the defendant will look at people's Twitter accounts, look at people's Instagram account and try and mount an argument as to their regard for their privacy, bearing in mind that they were publishing stories and photographs of themselves in private situations. If you do that, you are risking that argument being run against you. I'm not saying it's going to win, but it's the kind of argument that a defendant will run. And it's just harder to shut the window if you've had it open all day long. I guess that's the way I'd put it.
And of course this is an area law that does capture a lot of international interest at times, isn't it? But are there any examples of a more locally that you are able to speak about where we've seen instances like these?
Well, in terms of privacy, I can't think of many. I think that if I may say so, the press and GBC here are normally quite good at judging, in terms of private information, what sort of stuff can go online. I think it's very important in Gibraltar because it's such a small society, and if someone has their privacy infringed, it's something that they will feel very, very deeply, and it's something that will prevent them from, or they may feel will prevent them from having a public life. So I think that the press and the broadcasters have always been very good at steering clear of that. But yes, I think it's something that will be even more acute. In the UK, if someone has their privacy infringed, they can disappear to parts of the country. There's no way of disappearing in Gibraltar, and I think that people would feel it even worse.
In your talk, you touched on an old case, 2015, I believe, Fabian Picardo versus Manos Limpios,
yes.
Spanish Union,
yes.
I believe. So could you elaborate on that a little bit more?
That was a case where Fabian Picardo, the Chief Minister, brought a claim against the Spanish Union for damage to his reputation caused by defamatory allegations, which I won't repeat, but which were very serious allegations that had no truth to them. It wasn't defended actively by the defendant, who chose not to engage at all with the proceedings. He was adjudged to have succeeded, and then there was a hearing as to whether damages should be awarded, and if so, what level. And following oral submissions, the Chief Justice, Anthony Dudley, decided to award £30,000 in damages to recognise the fact that these were false allegations.
And perhaps a bit more broadly, how should The Rock treat potentially defamatory stories written about it by Spanish press, because it's something we are quite accustomed to some extent?
Yeah, it's a very tricky one, and it's something that often is hard to deal with, because a defamation claim can only be brought by either an individual or a company. It can't be brought by a country. So maybe defamation claims aren't really the way to go about it if it's an allegation against Gibraltar in general. I think probably educating, links with reputable people in other jurisdictions, I think is probably the best way to do it. Try and get our message out. Try and explain why what is being said is false. I think those are probably the most effective ways of combating that level of disinformation, and bringing a claim is probably not really going to achieve much and can sometimes be counterproductive.
A very interesting interview, Julian Santos speaking there to my colleague Shalina Asamo. Don't forget you can watch Viewpoint back online whenever you want on our website gbc.gi, and we've got more and more Viewpoint content on the GBC Newsroom YouTube account. We'll be back here on GBC Television next Thursday at the same time. From the whole team, thanks a lot for watching, and good night.